Hi, I'm Michigan criminal defense attorney Aaron J. Boria. Today, I'm going to be talking to you about domestic violence, the charge itself, possible penalties, possible defenses, and what you should expect when you go to court for the first time. So first off, what is domestic violence? Domestic violence is an assault and battery with one other element, and that is that you have some kind of personal relationship with the person that is accusing you of assaulting them or battering them. People that would fit that element would be someone that you've had a relationship with, someone that is related to you, someone that you live with, or someone that you had a relationship with would satisfy that relationship type element to be charged with domestic violence. It's very easy to be arrested for domestic violence. I've seen a lot of cases where someone simply picks up the phone, calls 911, and makes an allegation that their significant other has hit them or beat them, pushed them, shoved them in some way. Police show up and that person is arrested. Many times without ever hearing their side of the story, many times without finding any marks on the person who made the accusation, many times without hearing the background. A lot of cases occur because a divorce is going on. There's a child custody battle. Someone cheated on someone else. The point is that there tends to be a lot of motivation for people to accuse each other of domestic violence in order to gain ground, in order to better themselves, in order to punish the person, when no domestic violence actually occurred. Once you've been charged with any crime in the state of Michigan, you will first have to go to court for an arraignment. Arraignment can happen three different ways. You could be arrested, taken to the police station, and then the police will then take you in front of a judge or magistrate to be arraigned. Another situation occurs where you're arrested, you're taken to the police station, you either post a bond or you're simply released on your own, and you're given a ticket, and you're told to go to court for an arraignment. You show up and you have your arraignment. The third scenario is where you are arrested or you're not arrested at all. You're either given a ticket or you're not given anything, and either the court will contact you to show up for an arraignment or it's your job to contact the court and find out when you need to be arraigned. What is an arraignment? An arraignment is the first hearing at court, and at that hearing, the judge or magistrate will tell you officially what you've been charged with and what the maximum possible penalty is. Now, you may have posted a bond at the police station, you may not have. A bond is a promise to return to court and defend the charges against you. If you have to post a bond, you give the court money that they hang on to. And as long as you show up and you don't violate your bond, that money will come back to you if you're found not guilty or the case is dismissed. And if you are found guilty or you plead guilty, that money will go towards your fines and costs. You don't always have to pay money to get a bond and stay out of jail. There's also something called a personal bond, where the court says you're good on your word, you're going to come back, you don't have to pay any money, but if you violate, then you will owe that money to the court. And if you don't pay it, you'll go to jail while the case progresses. It is possible that the court will order bond conditions. In domestic violence cases, common bond conditions are no alcohol or drugs, you must test for alcohol and drugs, do not have contact with the person that you're accused of committing the offense against, do not be in possession of any firearms or weapons. These are probably the most common bond conditions. After your arraignment, the case will be set for a pretrial. Domestic violence is a misdemeanor for a first offense. It's punishable by up to 93 days in jail and a fine of $500 plus the cost of prosecution, cost of arrest, and any other mandatory costs determined by the state. A second offense, domestic violence, is punishable by up to a year in jail and a $1,000 fine plus fines and costs. Finally, a third offense, domestic violence, is a felony. It's punishable by up to 5 years in prison and $5,000 in fines and costs. There are a lot of defenses to domestic violence. As I alluded to earlier, many times people accuse each other of domestic violence because they have some sort of motivation, they have something to gain. It is to gain grounds in a divorce, a child custody battle, or for whatever other reason, just simply to get back at someone. Other defenses to domestic violence include self-defense. You were the person that was attacked first. You were defending yourself. The defense of others. If you see someone being attacked by another person, you are legally allowed to help the person defend themselves. Let me say that more clearly. If you see your brother attacking your sister and you step in and you defend your sister, who would have a claim for self-defense, you step in and you defend her against your brother, and then you are later arrested for domestic violence against your brother, you would be able to assert the defense of others. And if a jury believed that you were defending your sister, then they must find you not guilty. Other common defenses are accident, mistake, or simply that it wasn't you at all. Every case is different. Some cases will have many defenses, some cases will have a few, some cases will have strong defenses, some cases will have weak defenses. One of the most common questions I get is, how should I plead? Should I plead guilty to domestic violence? The answer is absolutely not. Until your lawyer and you have sat down and thoroughly discussed the case, and your lawyers advised you that it's in your best interest to plead guilty, you should not. I always advise my clients to first plead not guilty. Let us take a look at the case. Let us find out if there are any defenses available to us that maybe you haven't thought of. In many of the cases that I've taken on, where my client probably is guilty, we are able to resolve it, where my client's case is dismissed after they do a term of probation. If you simply just go in and plead guilty, you won't get that. It's also possible that even if you think you're guilty, one of these defenses may apply to you. I've had many cases where we've gone to trial, presented a defense, and my client was found not guilty. I'm criminal defense attorney Aaron J. Boria, and if you've been charged with domestic violence in the state of Michigan or any other crime, give me a call, 734-453-7806, or shoot me an email at borialaw@gmail.com. I'm happy to fight for you.